and welcome to Cyber Focus, your source for international business information. My name is Sarah Koh, and today we have Professor Norman Hedges here in the studio with us. Professor Hedges is the director of Indiana University Maurer School of Law's Intellectual Property Clinic and is also a clinical associate professor of law. Now, with close to 2 decades of patent practice at law firms under his belt, Professor Hedges' expertise lies in preparation and prosecution of U.S. and foreign patent applications, patent infringement consultations, intellectual property, among others. He was named partner at Faegre Baker Daniels in 2007 and worked out of their Indianapolis branch law firm. Now, in this interview, Professor Hedges shares with us the important work the Intellectual Property Clinic is doing and how imperative it is for businesses to properly protect their ideas and innovations for sustainable growth and success. Professor Hedges, thank you so much for joining us today.
Thank you.
Well, could you tell us a little bit more about your intellectual property clinic here at IU? Who's really involved with the work and what kind of initiatives and programs and services are you guys running?
Yeah, sure. It was not too long ago. Clinics have been around the law firm, law school environment for a while now. Historically, they've been more on the kind of the social justice side of things, landlord-tenant disputes, disabilities, applications, some divorce law, and that kind of stuff. More recently, they've gotten into some more of the transactional practice because the American Bar Association realized that law schools are pretty good about turning out students that knew the law, but they weren't so good about turning out students that knew how to practice law. So what they're trying to do is they set up these clinics to give the students an opportunity to come in and work with real clients under the supervision of people like myself, and I'm lucky at our clinic to have 2 other adjuncts that assist me in the clinic. But we bring in real clients because our work is all pro bono. They have to be of limited financial means, which usually typically ends up being startup companies, some not-for-profits, some individuals. They come in with their intellectual property issues, meet directly with the students. I try to have the students do as much of the interaction as possible so they can get used to working with clients, explaining things at the students or the client's level. So rather than spouting off statute numbers, they can kind of speak to the client's level. But after they come in, the students kind of do an analysis as to what the intellectual property issues might be, whether it be that where they have some sort of innovation that needs patented, maybe they have some sort of creative work that needs protection on the copyright front. Maybe they have somebody else doing some work for them and they need to make sure that they're securing the copyright on it. Perhaps they're coming up with a new brand to make sure, and they want to make sure that their trademark is protectable. And on the flip side too, we always try to remind the clients also that oftentimes you're kind of a little preoccupied with protecting your own intellectual property, but there's always the flip side of that coin that there's other people's intellectual property out there as well that you want to make sure you're not stepping on their toes. Because the last thing any company, particularly a startup company, wants to do is to be a year, 2 years into it to find out that they've got an infringement problem which could blow up their whole enterprise.
Absolutely. Well, the clinic definitely is running some really great programs and more sense a training program for both the law students but also great pro bono services for your clients. So you've obviously had significant experience in your professional career in helping businesses and organizations really protect their ideas and innovations. So in your opinion and from your experience, why do you think it's so important that both the private sector and even for some public organizations and groups to really embrace this movement and know that it's important to protect their property or their intellectual property?
It's historically been the case, and it's the same case for small businesses as it is for large businesses. But for the small business, the issue becomes that they are small and they're kind of easy to squash by the bigger players. So if they don't have a mechanism for protecting their assets, in this case it's their intellectual property, and they haven't done so properly, then the big guy is going to come in and just basically take their stuff and run with it, and they're out of luck. So by at least having their ideas and their creations protected, they have an opportunity to avoid that situation and provide a little barrier, a little buffer between them and the big guys, so again that they don't kind of get squashed.
Yeah, absolutely. And again, drawing back from your experience, practicing in the private firm as well as your current position as the director at the Intellectual Property Clinic, what kind of success cases do you remember or you find most memorable that from the companies that really reaped the benefits of protecting their intellectual property?
Yeah, I think the best end result, some people think that the best result is you go out and you secure all this intellectual property, and then you go out and you beat people up with it, and you're constantly suing and being aggressive and that kind of stuff with your intellectual property. That's really not a very good business model, because obtaining intellectual property is kind of painfully expensive to begin with, which is again kind of why our clinic exists, is to kind of give some of those cash-strapped entities the opportunity to protect their IP. But enforcing your intellectual property is even more painfully expensive. So what you really don't necessarily want to be doing is going out there and constantly having to enforce your intellectual property, because it's very, very expensive. But what you do want to do is to establish a reputation that you are going to, one, protect your intellectual property and enforce it. And if you can get that reputation out there that you're going to protect your stuff and you're going to enforce your intellectual property, people are going to stay away from it. And you're not going to have to go out there and enforce it. The reputation that you are an aggressive protector and enforcer of your intellectual property is going to be enough, hopefully, to keep people away, so that you don't have to go through the expensive process of enforcing your intellectual property through litigation.
Well, since the clinic's opening, how has the response been from the public and our Indiana residents who are either aware or have used the clinic themselves?
It's been quite tremendous. We've been up and running since a little over a year ago. Our official launch was actually in September of last year. And in that time, we've had in the area of 80 to 90 clients in that time frame. Which is a substantial number of clients, particularly when you've got one full-time person monitoring the students and supervising their work. But about half of that is patent related, so roughly 40-45% of those folks come in looking for patent advice. Sometimes it results in that their idea is not patentable, which is fine. It'd be better, obviously, if it was patentable, but they've saved themselves the expense of going out and spending $10,000-$15,000 on a patent application that's worth nothing. Probably another third to 40% on the trademark front. Again, a lot of those don't result in trademark filings, but a lot of times what they do is we end up finding an issue for them that maybe the name for their company or the product that they found has got an issue dealing with it, and they can avoid that so that later on, again, a year, 2 years down the road, they don't have to pivot with their branding. We consider risk avoidance or risk reduction a victory as well, or a good result for the client. And the rest of our work, 10 or 15 is in the copyright arena with agreement work and that sort of thing. But we're finding that we're starting to get inundated because word is getting out that the service is there. We're so new that we don't have that enough capacity to handle all the work that's coming in. So what we're trying to do is set up a network of referral partners. The Kelley School is one that we work with. The Purdue Foundry is another one. The Indiana Small Business Corporation. They're basically our referral partners, and what we're trying to do is make sure these clients have some sort of mentoring or coaching in the entrepreneurial space when they come to us, so they have an even better chance of being successful, because merely getting intellectual property is not what's going to make your business. It's one tool in your toolbox, but having the other tools that these other service providers can have you, we think is going to increase the chance that these enterprises are going to be successful and create jobs and all kinds of great opportunities for folks.
Well, finally, if you could maybe leave us with a helpful advice to businesses or organizations who are either not aware of how important protecting their ideas and innovations, especially for small to medium-sized businesses, could be, or a group or business that haven't really ventured into looking into these services or even our clinic, what would it be?
The best piece of advice is to consult with somebody early on. Intellectual property is often a very time-sensitive matter, particularly on the patent front. If you sit on your rights for too long, you're ultimately going to waive your patent rights. But even on the trademark front and the copyright front, there are time-sensitive things to do in there. Again, you don't want to get yourself in a situation where you pick what you think is an awesome name for your product or your brand. You find out a year and a half, 2 years down the road that somebody else is already using that, and you have to pivot. Nobody wants to rebrand. I think the areas of growth in the future are going to be in the copyright arena. We are to the point now where we have developed such a cut and paste mentality when it comes to grabbing content for websites and all that kind of thing, that there's actually kind of a cottage industry developing. They're called copyright trolls, where they put their works out there just hoping that somebody copies their material, puts it on their website, and then you get a cease and desist letter later on asking for $3,000, $4,000, $5,000, where they know full well that it's probably going to cost you that much in legal fees, even to figure out if you have an issue. So I think that is going to be an ever-increasing area of issues for people that are using the social media, their websites, and those sorts of things to promote their ideas and their concept and brands. Just to watch out for those things. But when in doubt, ask a question. That's one of the reasons we're here for the clinic, is that a lot of times these startups just don't have the resources to go hire somebody that's billing out at $300, $400, $500 an hour to pay them for that. That's why we're here. Come ask us. We're here to provide that service for you.
Wonderful, Professor Hedges. We definitely appreciate the insights that you've shared with us, and thank you so much for stopping in.
You're welcome.
Well, that's all for this edition of Cyber Focus. Thank you so much for joining us. Now, if you have any comments or suggestions for future topics, please let us know at CIBER, that's CIBER, @indiana.edu.